the cause of action arises out of violation of a property right and not of personal right, cause of action survives the death of the wrongdoer. Singley versus Bigelow. All right, so that is the authority that I'm citing. Yes.
So, how did you come up with those authorities?
That's called research. You
go. All right. How does one go about researching something like that?
You've got it. Look. I didn't know, so I went to the law library. I said, death. You know. Okay. You start looking up. Let's see. Is there some way that I can deal with this? You know, you. It's like on the internet. You put in keywords and see what pops up. Believe me, there's a lot of reference books out there. You look up in American Jurisprudence again. You look up in Matthew Bender's Forms of Pleading in Practice. It's called research. You don't know in advance. You know, you got a problem, and you pick out the best words you can figure out that might apply to the problem. You start looking up in these reference texts. It is a search problem, definitely. I mean, I wasn't getting smarter with you. It's actually you're dealing with the unknown when you start, and you have to get in and look. And there is a biblical reference to that. I think it says, "Seek and ye shall find." Okay, and that's exactly how I did this. I did the seeking and I did the finding.
And it also says my people perish for the lack of knowledge.
Right, but how do you get knowledge? You go hunting. You know, how do you get food in the jungle? You go hunting. You know,
due diligence.
When doing points and authorities and mentioning case law, we should cite as we're illustrating principles of law that were decided on, let's say, some previous Supreme Court cases, and we have a right to rely on that unless they get overturned.
Well, look, if you're in your sovereign capacity, case law does not apply to you. Black letter law does not apply to you. On the other hand, public opinion is of a direct interest to you. So, because it's a direct interest to you, because you want to look good, yeah, you do pay attention to case law. But it's not binding. It is binding on the judges. It is binding. They took an oath to support the laws and blah, 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 okay?
Right.
So, yeah, I hold them to those standards. But for myself,
gotcha.
The sovereign, remember what it said? The very essence of sovereignty is that the sovereign decrees the law.
Right.
When I set up my court cases, I decree what the rules of court are. Quite often, in a state case, I decree that the rules of court are the federal rules of civil procedure. I toss out the entire California rules of court that way. It's my court. Yes, sir.
Now, when researching the case law, you'll notice that there are good case law, and as you go along, what happened here?
You go along in the case law dates, and it says, "Well, this one's better. This is that's 1930s. It might be another, but
yeah, you're talking about
1940s shepherdizing." Mm-hmm. When you're the sovereign, you select which one. Do you listen to that in your research?
Well, yes, because you see, these cases that are written, the court has gone public on its reasoning process, and the courts are in a glass, they're in a fishbowl. And so when you read these opinions, they're pretty solid usually. At least that's been my experience, my interpretation.
So you want the latest?
Well, yeah, you want the best of the reasoning, but you know what? All of these cases that I've ever seen, like our class of people seem to run into, they're very fundamental. They don't depend on fine points of the law, which, by the way, is not law at all. But, all of our cases are pretty gross. Somebody came and beat somebody up. And where was the warrant? Or where was it? We deal with raw power here, and it's very crude at times, meaning it is raw power. And so shepherdizing a case, I suppose you could do it, but I've never shepherdized any of my cases, except right in the beginning I figured it out, and I said, well, wait a minute. My cases are so gross, so plain, so simple that common sense tells you where the right and the wrong of it is. You don't have to be any trained jurors to realize that somebody punched you out when you didn't ask for it. You know? Right. That's what I'm saying. I haven't felt the need to really genuinely shepherdize in depth. I just go for the surface, look up the latest books, get some reasonable closeness. If the case appears to apply, I use it. I'll tell you, I've never had anybody come back and say that one of my cases was superseded by one of their cases. Never had that happen.
I notice the other side sometimes uses cases don't even apply to what they're talking about.
Yeah, you know, there's and a lot of times if you do get a case that's cited, you know, from the opposition or one you use yourself, be sure to read it. Go and read it, because a lot of times they misquote it. In fact, there's a case. It involves a police officer who was looking for equal protections under the law because he had scored too high on a test, and they wouldn't hire him. He was too smart. The average intelligence of a policeman is 104 IQ. Okay? It's the same as secretaries and bank tellers. So he had scored something way up there, 120, I guess, or I don't know, 118, somewhere up there. And because he had scored so high, he felt he merited the job, but they wouldn't hire him. And he claimed a few things, but one of the things that he brought into the case, this was in the state of Maine, and just recently too, meaning in the past 10 years, I think, he tried to bring in some issue of sovereignty, personal sovereignty, okay? I don't remember how he tried to fit it in. And the Supreme Court itself, one of the Supreme Court justices misquoted a prior case. And I knew about it because I looked it up. And sure enough, he had misquoted. It didn't quite fit in my mind, you know, and having something to do about sovereignty. And he was denying it, and he actually put it in quote marks, but when I read it, it was nowhere in the case.
So what did you do?
I didn't do anything. It wasn't my case. It was in Maine, and I was here.
Okay. What would you do in the... Well, you'd have to know, I guess, during the trial. But after the fact and his final decision, if he made something that was that he based, the whole thing was based on a misquote, what would you do? I'd
make a motion for reconsideration.
Okay.
Or motion to change the judgment. You can move for anything.
Yeah, right.
And you'll find some case somewhere that supports your idea of what should be done. There's plenty of cases out there.
Interpretation.
Oh yeah, whatever.
Okay.
There's plenty of case law. There's now case law for any position you want to take, actually.
Yeah.
So, anyhow, yeah, see, the idea, what I want you all to understand is that, although I'm talking a little bit, you notice how how often do you see a request for substitution of plaintiff?
Never.
Yeah, that never happens. What I want you to look at here is the form that it's in. Okay? Because this form applies to everything. All motions. Alright? There are certain specialized motions that might require specialized forms or certain factors, but this is what you base it on, this particular form. And so you can see, and I put it in complete form with line numbers and everything so that you could see. Alright, so we quoted the cases. We're back on the brief here. The brief has two names. Sometimes it's called a brief. Usually in California it's called points and authorities. It means the same thing. So now that we've got the authority, we made our point first up above. William R. Thornton should be substituted for plaintiff William C. Thornton. We made our point. Now we put in the authorities, case law that we found that was relevant. And then we went to the argument. And so now, starting with line 17, this is where I'm arguing before the court. Okay, just as if I were standing in front of a jury. And I say, cause of action survives decedent because it arises out of a violation of property right. William R. Thornton is the representative of William C. Thornton. Also, substitution would represent a change in form only and not a change in substance. Okay? The settled practice is to allow substitution of personal representative. Therefore, application of William R. Thornton to be substituted for William C. Thornton should be granted. Respectfully submitted.
We're coming to the end of the 4-hour DVD, so
okay.
We'll wait to reload. That'd be great.
All right, well, let me, are you at the end or you're coming to the end?
We're about 20 seconds away.
Okay. Well, yeah, I think that's a good breaking point.
That's a good point. Okay.
Yeah.
Okay.
Yes. Okay. Now, we interrupted a question here. What was the question that we interrupted?
The question is, what was the question?
Who asked the question?
I believe the lady back there. Didn't you?
That was Brett.
She'll never.
Oh, I see. I know. We were ready for the next item on the list here. All right. So you have on your points and authorities, you have the point being made, the authority supporting the jurisdiction, or the applicable law, whatever it is, and you don't have to just quote law. You can quote cases, you can quote philosophy, you can quote the Bible if you want. All the moral support. But these are authoritative sources, which aren't, maybe they're binding, maybe they're not on the tribunal, the judge, whoever the judge may be, even if you're the judge, the tribunal. But this is where you argue your case. Just like if you were in front of a jury and you are arguing your case, you're saying, here's why you should decide in my favor. So that's where the argument, item 4C, that's where you jump up and down and beat on the table or whatever. Oh, which reminds me of an old legal saying, that when you have a strong legal case, you beat on the judge. When you have morality on your side, you beat on the jury. You pound on the jury. And when you have neither the law nor the morality on your side, you pound on the table. So, anyway, on 4C, this is where you do all that stuff. You argue your case, just like you're talking. You talk on paper. All right, so now we have the proof of service. More and more, the courts are going toward mandatory forms. And right now, if you file an original lawsuit, you get a summons, it is mandatory that you use the proof of service that's specifically designed for a summons. Well, it's okay. It doesn't really affect your rights. You can do that. But watch out for these forms because, again, you don't want to be in conflict with the clerks. You want to work with the clerks. And these forms are usually okay. And if you do have a form that they love for you to use, but it doesn't quite fit, all you have to do is, on the appropriate item, all you have to do is say, see attachment. And then you take a blank sheet of paper and you put it with it, that's your attachment. And then you say or do whatever you're going to say or do. So, that's all it takes for that form. Or any form. You can always modify it. They don't seem to have much rules against modification as long as you do it by attachment. On some forms do have an attachment form. So if you have more to say, apparently on these forms there have been enough variation that they couldn't get around. They actually made up a form for a variation to the form. Okay? It's called an attachment or addendum or something like that. So anyway, but you make a proof of service. What I'm going to show you here is a general proof of service that we used to do. It's the old way of doing things, and I kind of like it. It gives me a little flexibility, but a normal form, an actual form from the Judicial Council does work. That's why they make them. So here it is. This form is what I often do. You'll notice that there's no caption on this form. Okay, there it is. That's the whole form right there. Basically, a form, a proof of service, is simply another affidavit. Okay? How does the court know, how can the court have confidence that you delivered the paperwork? Okay, here's the tribunal sitting here. And the question before the tribunal is, did everybody be properly notified that this is going on? And if you have a proof of service, that is what the court is going to use to determine that everybody has been properly notified that they have an interest here. Okay? That's all it is. So here it is. It says, I am employed in the county of Orange, state of California. I am over the age of 18 and not a party to the within action. All right, that's important. Not a party to the action. You cannot mail, serve, or in any way give your papers to the opposition or whoever is interested, yourself. You have a vested interest in winning your lawsuit. Therefore, your proof of service is no good if you signed it. You have to have somebody who is at, as they say in legal language, who is at arm's length. Okay? That person has no interest in the outcome of the lawsuit, no direct interest, and so is therefore more trustworthy. When he says he delivered the paper, then you know it's so. Now remember this. Let's say you serve somebody by mail, which you can do. Once you have somebody in jurisdiction, you can serve by mail. But you have to have somebody, again, third party, who's not connected to the case. If you're married, you're suing somebody, your spouse can serve the papers. Okay? The spouse has no direct interest in it. Indirect maybe, yes, but not direct. So it's legit to have your spouse serve the papers for you, or your girlfriend or boyfriend, or whoever, okay? Just don't do it yourself. No party in the case can serve the papers. So you're declaring here that I'm not a party to the action. My business address is such and such. You can use any address, home, business, doesn't matter. I have to warn you about one thing. If you're going to make a habit of serving papers, then the state of California requires that you register as a process server. Okay? That's one of their little requirements. Doing an occasional service for a friend or something like that doesn't qualify. And I believe that if you don't charge for it, then it doesn't qualify for regulation. It's only when you're charging for it, you have it as a business. And I forget what the criteria is, but there's some criteria, and it's on the forms, by the way. I think it says, I certify that I have not served more than so many per year or something. Did anybody remember that? No. Anyway.
Yeah, it's, you're not allowed to serve or pay more than 10 papers per year.
No more than 10 papers per year, okay? So that's cool.
Yeah, you're quite correct. You can serve as many as you want.
Yeah, for free, you're not in the business. That's a different story. But anytime you start getting engaged in commerce, guess who wants to regulate it? Okay? So, anyway, that's the only warning is that if you're going to make a habit of it, by all means, then consider the fact that you may have to register.
Bill, is there any problem with changing the word within to the place that we're action and vice versa? So it reads a party to the action within.
We don't hear any of this.
They can't hear you. Microphone.
Okay, he's asking, can we change the words around? Well, yeah, you can change the words. I mean, all you have to do is speak English. Plain English works.
Isn't changing it around better understood? I mean, isn't it?
Well, maybe for you, I understand it perfectly well. But if you understand it and I understand it, okay. Sure, you can always rewrite things. There is a formula which was stated by Mark Twain, a.k.a. Samuel Clemens, and he provided the surefire rule for good writing. It was revise, 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 revise. Okay? When you have 7 revisions, your writing is bound to improve. That was his rule for it. So sure, I'm sure we can improve this with a little extra revision. Anyway, but this qualifies, all right? On November 24th, 1986, I served the foregoing documents described as, and I name every single paper in it. Okay, the application for substitution of plaintiff, the declaration, the points and authorities, the order for substitution, it's actually a proposed order, and I guess something like that, whatever. On the interested parties in this action by placing a true copy thereof enclosed in a sealed envelope with postage thereon fully prepaid in the United States Mail at Anaheim, California, addressed as follows. And then I list every single address that I mailed to. I am, you give your own name, okay? I have the person who's doing the serving. I am so-and-so, I have personal knowledge of the above facts and am competent to testify as to the truth of those facts if called as a witness. I declare under penalty of perjury that the foregoing is true and correct and that this declaration was issued in Anaheim, California, November 24th. And it's just an affidavit is all it is, saying what you did. And we've had complications in service. You know, I'd serve somebody and this person would pretend to be somebody else. You know, you have these games. Hey, when I'm doing service, I put that all in there. I say, this is what happened. Well, what does that do? The court looks at it and they say, well, that sounds reasonable. Yeah, we think the guy was served. Well, it's okay to tell the truth. It's amazing, you know, what they do. But let me explain something about service. Service is kind of interesting. There are different ways to serve people. And the biggest thing is getting the first service, because once you have somebody in jurisdiction, then you can serve by mail. But before you can serve by mail, they have some standards for service. So the highest quality of service, there's levels of quality. And the court is aiming for the highest quality, of course. So given first choice, the clerks would prefer that you have a third party go over and hand it to the person and say you are served. Okay, this is a lawsuit. That's all you have to do. And they don't have to take it. You know, if somebody comes back and refuses to take it, you've already informed them, right? You just drop it at his feet and walk off. He's served. Okay? Don't worry about formalities. Don't worry about getting them to sign a receipt. You don't have to do any of that, okay? You just take it, say, are you so-and-so? He says, yeah. Well, these are legal papers. You're being sued. You don't want to take it? Drop it on the floor and walk off.
That's right.
Okay?
That's exactly right.
That's right. You don't... He has been informed. That's all the court wants to know. Yes?
Before you can revert to substitute service, what procedures do you have to go through?
All procedures are substitute services except the one I just told you.
But before you can rely on substitute service, what do you have to do?
You don't have to rely... No, you don't have to do anything. You can do substitution of service if you wish without any other effort.
So you're not required to personally attempt to serve?
No. No. You can... What you can do is, you see, there are... The first two levels, either way is good. Okay, you can do service or you can do substitution of service on the first two levels. The first level is what I just told you. You've had personal contact with a person, and you just drop it on the ground if he doesn't want it, or leave it on the counter. You know, a lot of times we serve courts. We serve judges. We go right in. The marshal's there. You say, this is legal service. He's the gatekeeper. I can't get to the judge. He's the person apparently in charge. I just hand it to him. I say, hey, and this is the second level actually. Okay? If you can't find the person himself, then the second step is you give it to the person who is apparently in charge of the office. Even if you don't know his name. Okay? You don't have to know his name. What you do, ideally you want his name. You say, on such and such a date, I served somebody with these papers for so-and-so, or whoever it was for, okay? And you give it to them. They know if they're over 18 years old, they're assumed to be responsible. You give it to them. It is their responsibility to hand it to the next one, and it's prima facie assumed that he will give it to that person. However, the courts recognize that service like that is not as good as personal service.
Do you need that person's name?
No.
Who was left with?
You don't need the person's name. All you have to do is describe the location, describe the person. If you don't know his name, say, well, 5'2", eyes of blue, okay? Age, weight, you know, a description of the person and what time of day it was that you were there, so as the question ever comes up, you can pinpoint who that person was. Because ultimately you're going to get to somebody responsible in that house, and they'll know who that person is. You see? So they can't dodge it that way. They don't want to give you a name? Okay. I got the description. I saw who you were. I saw the hair you had, the clothes you were wearing, the approximate age, weight, color, eyes. You know, I get all that. Or if you can't get all that, you can't remember it all, get it as close as you can. But the courts recognize that that is not quite as good as personal service. So the courts require in their rules a secondary simultaneous procedure. You mail it to them. Okay? So when you hand it to the person, it's a targeted service. When you do the second level service, it's a two-shot service. One is the giving it to the adult who's apparently in charge of the office or responsible for the home, and the other one is mailing it to the same address. By doing that, you now achieve the same credibility. The person cannot say he didn't get it. Now, as a little side note, do not send it by certified or registered mail. Why? Because when they refuse it and it comes back to you, that becomes proof that they did not get it. The courts presume that if you mailed it, they got it. The post office is basically trusted. Okay? Right. So do not send it by certified, or if you want a little receipt, you can get a receipt from the post office saying you put it in, but once it gets into the postal system, it goes, and there is no, the burden is on them to prove that they didn't get it. I don't know how they would prove it, but they could prove it. Yes, sir.
If you do certificate of mailing...
Yeah. You can do a certificate of mailing, that is true, but because that does not inhibit the process. They cannot say that, you see, with a certificate of mailing, all you're doing is getting a receipt from the post office saying that you handed it them. But again, it's not you personally. You want a third person who's at arm's length, who does the actual mailing, who does the actual substitution of service process, and he makes up a proof of service saying that's what he did.
With a certificate of mailing, the postal office will always say they have to fight the post office that it wasn't delivered. It doesn't come back on you, it goes on the post office.
Yeah, whatever it is, I'm not sure how you prove you didn't get something when it's mailed openly like that. Yes.
Well, I just want to finish this up. There is a code that's under, geez, I can't remember right now. But anyhow, it says that they can, under certain circumstances, accept certified mailings if upon a signed receipt for delivery. In other words, somebody signed for it, and you get the green card back.
Oh, well, yeah, if they got it, that saves all argument. I'm just saying that don't send it, because if they refuse it, it becomes proof they didn't get it.
Yes. But is it actually proof that they were properly served if somebody signed for
well,
the receipt?
if they sign it, no, it's not necessarily proof. The proof is in the proof of service you filed that it got mailed.
Okay.
That becomes backup evidence. That's not the basic evidence.
Yeah.
Because, see, the person signing it and the receipt comes back, that's not proof of what's in the envelope. That only proves they received something. You need the proof of service that you actually put it in the envelope, you sealed it, and you mailed it.
Well,
and how it was addressed.
Without, in this case here, they're not accepting that as proper proof of service.
What do you mean?
Even though it has the proof of service, the affidavit that it was properly served, and the postal receipts, including the green card with the signature on it.
Look, all that green card does is give supplemental evidence. The real evidence is in the proof of service made by the person who dropped it in the mail.
Yeah.
That's if you do not have a proof of service and all you have is the green card, that's not going to work. Because all the green card proves is that they received an envelope. It doesn't say what the content was.
Well, we had the proof of service too. That's not the consideration.
Well, the proof of service is all you need.
It doesn't matter. Certified mailing with proof of service return and the proof of service.
Well, what's your point then? If it doesn't, I'm missing something here.
I'm just trying to get your view because the court said no.
No what?
That's not sufficient service.
What's not sufficient service?
Certified mail with proof of service return attached to a proof of service form.
But if you...
yeah, well, again, yes, the